We have, so as we have Momentous Title, which is our in-house title company now. And one of our underwriters is Title Resources Group, which is actually an Anywhere company also. And they have all sorts of good education we're going to start leaning into and mix up our classes kind of. And this one came up this summer a couple of different times, and title objections come up relatively frequently. So we asked them to give us this class, and I visited with Thad about it. He's been super helpful to me, and now he's going to bring it all to you guys.
Oh, thanks for having me. My name is Thad Bernacci. I'm an attorney with Title Resources Guarantee. As you heard, we're one of your underwriters for your title company. We are quite literally invested in your successes as having a kind of a common parent company, but we're figuratively invested in your success as well. If you got questions that are related in any way to real estate law, related in any way to your transaction, or just maybe a contemplated transaction, feel free to pick up the phone, give us a call, and we'll be happy to answer those questions so that you can get your deals closed with as little hassle as possible and hopefully with the greatest understanding possible. So today we're going to talk about title commitments and your ability to make objections to them. So hopefully if I could just get it, I think I've already got one from Angela. You're seeing on the screen, I object, the basics of title commitment objections for realtors. Yep. Okay. Fantastic.
Yep.
So you will get 1 hour of TRG CE credit for this, by the way. That's just a housekeeping slide to go there. But what is an objection and why is it done? All right. So let me just preface this by saying this is the 50,000 foot overview class for realtors. If I was going to teach you exhaustively on objections, we have other people that have prepared, text on this. It's about 60 pages of double column, single spaced text with about another 40 pages of exhibits. It would go on for hours. All right. So our objective here is to give you a better understanding of what can be done and the process for doing it, but you'll probably leave with questions. Don't feel bad about that. Pick up the phone, call me, and we'll talk about your specific situation. Okay. So simply put, an objection is the buyer objecting to certain items in their title commitment that will limit coverage. So if you've never bothered to read a commitment, you can Google Texas T-7. That is the standard title commitment form for every title commitment that's issued in Texas. Now, of course, there will be unique items on there for your particular transactions, but the basics of it, what they're telling you, what's an exception and an exclusion, standard printed exceptions, those are going to be the same across the board. So if you've never done that, take a moment to do that. After this class, I'm going to email Zareen a couple of attachments. One of those will be a standard commitment, okay, with blanks in it. So that'll be a kind of something for you to review. But all of those exceptions and exclusions are telling you these are things that we are not going to cover. All right. So that should be, in essence, a warning flag, right? Here's things that the title company doesn't want to cover. What am I have a chance to say? I want more coverage. Okay. And if you want more coverage, you're getting that through making objections, right? As well as making some requests in the policy. I'm sorry, not in the policy, in the contract. Every realtor should tell their clients to review their title commitment and the associated documents. That commitment is going to come with oftentimes hyperlinked documents, depending on where your transaction is. You might have a title company that doesn't have hyperlinked documents, but you actually get the physical documents. They need to review those because, of course, they have that affects their contract. Now, that's about as much as you can tell them. You cannot practice law, so you cannot tell them exactly what this means for their transaction and for their title insurance coverage, but it is important for you to stress to them to contact an attorney if they have any questions on that matter. And for some of them, they can just contact the title company. We'll be happy to tell them what we can and cannot cover, why and why not. All right. A title commitment itself can be viewed as a checklist of what we will and of what will and won't be covered in the owner's title policy, which is what you ultimately care about. Now, you'll see a lot of items that are listed as T2 on a commitment sometimes. T2 is referring to a loan policy. Those are not ones that you would need to worry about, and of course, unless you're representing the lender. Okay. In addition to that checklist of what will and won't be covered, which is typically the Schedule B items, that's what you're usually most interested in as a buyer, there will be a list of what you need to do to close in Schedule C. Those are really going to be of the most interest to the seller. That doesn't mean the seller is not going to be interested in Schedule B, but they're most interested in Schedule C. Okay. But like any roadmap, there's more than one way to get where you're going. And like any checklist, there are some things that you might need or not need on that checklist. So how can we change that? Simply put, as a competent realtor, you should know that your client has a right to object to some, but not all of the items in a commitment, which could, of course, expand their coverage, which would be a good thing for them, and give them the opportunity to cancel the contract and get a return of their earnest money, which is, of course, if you're representing the seller, also a source of concern. How many outs are they getting in this contract? Well, the answer is going to be, what do you have in your contract, and what do they have a right to object to in the commitment? And let's look at the commitment to see what might be problems. All right, so where does this right even come from? Well, it really starts in paragraph 6B of your one-over family contract. Paragraph 6B says, within 20 days after the title company receives a copy of this contract, the seller shall furnish to the buyer a commitment for title insurance, and at buyer's expense, legible copies of restrictive covenants and documents evidencing exceptions in the commitment. Okay, so you're going to get within 20 days. I hope it doesn't take 20 days. Okay. Typically, it's a much shorter time frame, but again, it depends on a couple things. Number one, the county where you're located. Number two, the actual title company you're working with. And number three, I guess, volumes of transactions. You might get a commitment right now in 2 or 3 days in Dallas County, but if we move back in time to where there's an overwhelming number of refinances, that 2 or 3 days might become 5, 8, or 9. Okay. Likewise, if you're deep in East Texas, where you're dealing with a smaller title company that doesn't have hyperlink commitments, you might be 15, 17, 18 days to get the commitment. All right. So that will vary from area to area, title company to title company, but have some feeling for how long that takes. Now, what if it doesn't happen in 20 days? Well, we've got some procedures there. So let's start again here. Within 20 days after the title company receives a copy of this contract, the seller shall furnish to the buyer a commitment along with the documents. Seller authorizes the title company to deliver the commitment and its exception documents to the buyer at the buyer's address shown in paragraph 21. Let's stop there for a second again. Think about paragraph 21. Okay. Oftentimes, paragraph 21 is only partially completed. It probably has the buyer's information because you're submitting the contract. It may or may not have the seller's information. That's potentially problematic because who are you going to deliver the objections to? Not to the title company, you're going to be delivering them to the seller. Okay. So as a buyer's agent, make sure we have paragraph 21 completed. That advice doesn't go just for the objections. Every notice in the contract goes to the people in paragraph 21. And when we teach legal update, TREC is now stressing, although of course it's not a legal requirement, that the party's information is what's filled in paragraph 21, not the agent's information, right? That's smart advice because it helps limit some of your exposure. There are plenty of agents that don't want their clients' information in there because their clients will freak out. The contracts will go south. I get it. However, think about having the party's information there nonetheless. You remember that we've changed paragraph 21. You usually just say to buyer at, to seller at. Now it says to buyer at, to seller at, and then below it says with courtesy copy to buyer's agent at, courtesy copies to seller's agent at. All right. So they're really trying to get you to put the party's information in there instead of your own. By the way, as a separate side note, completely outside this class, think about this. Okay. We have Senate Bill 2 passed, which is going to change homestead exemptions and the tax rate, provided that it all passes in the November election. So transactions have been prorated based on last year's taxes and are still being right now because we don't know what the tax rate is. Well, we assume that Senate Bill 2 will pass when we have an election in November because it requires a constitutional amendment. But even if it does, we don't know the rate yet. Okay. So there will be, most sellers will have overpaid property taxes for this year. Okay. Which then requires, or not requires, but gives the parties the options to go back and adjust for that. Right. The seller can say, hey, I overpaid by $3,000. You owe me that money back. That's in the contract. How do they get a hold of the other party? Well, if it's just the agent's information in there, guess who's going to be the go-between? Right. So another reason to think about putting the buyer and the seller's actual information. So for all these tax adjustments that have to take place, you can say it's in the contract. It's an agreement between you two, not the agent, but you two, and here's their contact information. All right. That was way more of an aside than I intended. I apologize. Continuing on from there. If the commitment and the exception documents are not delivered to the buyer within the specified time, we just extend the time. The time for delivery will be automatically extended up to 15 days or 3 days before the closing date, whichever is earlier. Okay. If the commitment and the exception documents are not delivered within the time required, the buyer may terminate the contract and the earnest money will be refunded to the buyer. Now, a couple things there. We have 20, but if it can't happen within 20, we extended 15. So it's really 35. something really is strange going on if it takes 35 days to get a commitment. But one way or the other, there is a definite cutoff, whether it's at the 35 days or the 3 days before closing. If you don't get it by that time, you have an option to terminate. But it doesn't mean that the contract is terminated. You simply have an option to do it. So step one with all of this is calendaring when you should get the commitment and understanding you have the opportunity to cancel if you don't get it within those timeframes. Okay. Now, when you get the commitment, there's a few things. Schedule A, if you've never looked at a commitment, looks like Schedule A of the final policy. It's got the name of who the insured is going to be, who the lender is going to be, what the loan amount is, what the purchase amount is, the effective date, all that type of stuff. The legal description. All of those things should be spot on with your contract. If they're not, bring it to the telecompany's exception. Where we're going to start for objection purposes is with Schedule B. Now, again, what is Schedule B? That is the checklist. It's not the roadmap. The roadmap is C, what we have to do to close. Schedule B is, these are the things we're not going to be covering. Okay. So in addition to the exclusions, and this is what your T7 will say, in addition to the exclusions and conditions and stipulations, your policy will not cover loss, cost, attorney fees, and expenses resulting from, in plain English, we're not going to cover this next list of items. The following restrictive covenants of record itemized below. Now, typically, this is where you're going to see all of the conditions and restrictions that apply to your property. They don't list them out, but they will put in the documents where they exist. Okay. Those are things that are unique to your transactions. It's the first place you're going to see them. Okay. And somebody should review those documents. And the vast majority of residential transactions, that won't happen. And every commercial transaction will happen. But for most residential transactions, that's not going to happen. All right. So we're going to list off the covenants, conditions, and restrictions, hyperlink to those documents. We're going to tell you we're not going to cover an issue that relates to that. Number two, we're not going to cover any discrepancies, conflicts, or shortages in area or boundary lines or any encroachments or protrusions or any overlapping of improvements. We don't cover surveys issues by default. Now, you already know that that can be changed. So again, that's something that can be modified. And we'll talk about objections that go with that because it's going to be one of the most common objections or the objections that will go with your request for survey coverage. Okay. Number three, homestead or community property or survivorship rights, if any of any spouse or any insured, any titles or rights asserted by anyone, including but not limited to persons, the public corporations, governmental entities, or other entities. And it's essentially we'll talk about it, shorelines, whether that be a lake, a riverbed, the ocean shoreline, etc. Okay. Standby fees, taxes and assessments by any taxing authority for the year blank. In no case should that be earlier than the current year of the closing and then the subsequent years. We're not going to ensure that someone who's paid taxes in the future, just that they've been paid up to this point. Now, that is primarily a lender issue, but it's still something you would want to check to make sure you don't have an exception for instance, last year's taxes. Why would that be the case? 6, the terms and conditions of the documents creating your interest in land. Number 7, materials furnished or labor performed in connection with the planned construction. I'll shorten that down because what you'll see later is in the parenthetical applies to the loan title policy binder on interim construction loan only and may be deleted. This is a lender issue. You don't need to worry about number 7. Okay. Likewise, number 8, liens and leases that affect the title of the land but are subordinate to the lien of the insured mortgage applies to the loan policy. You're not worried about that. What that's telling a lender is maybe you're in first position and there's a second lien. Okay. The second lien or liens that are filed in the future, maybe there's a home equity lien. These are subordinate and we're not covering those. And you don't need to worry about them because if they're subordinate, they're inferior. Number 9, the exception from coverage and express insurance in Schedule B of the short form loan policy or other separate exclusions again, but that is a loan policy issue. And then number 10, the following matters and all terms of the documents creating or offering evidence of the matters that we reference. 10 doesn't really say anything that means anything to you yet, but this will be unique to your transaction. In B10, there will be a list of things that are specific to your property and your transaction. B1 and B10 are the ones you're going to focus on for objection purposes, primarily B10, but you'll also have a right to make some objections to things in B1. All right. Now, there are a couple other things you can make objections to. For instance, we'll talk about those, what might appear in B10. All right. Now, where did those exceptions come from? Unlike other states, Texas is one of only a handful of states. And by handful, I don't even actually mean 5. I think 3, where title insurance is so regulated that the forms themselves are promulgated by the state and are not subject to modification. If we modify any of those terms, it's pursuant to a rule promulgated by the Department of Insurance. It says, this is the change you can make, if any at all, and then here's what they have to provide in order for you to make that change. Many of those items we just talked about cannot be changed. All right. So we've talked about the commitment briefly, but we're here about objections. So objections comes in paragraph 60 of your contract, and it says this. We're going to go through this more than once because there's a lot here. Okay. Buyer may object in writing to defects, exceptions, or encumbrances to title disclosed on the survey other than item 6A1 through 7 above, or disclosed in the commitment other than 6A1 through 9 above, or which prohibit the following use or activity. Let's stop there. There's 2 things you're looking at. The first thing is the survey. There will be items referenced on the survey that you cannot object to. Well, what are those? I've jumped forward a couple slides. This is 6A, 1 through 7. So if I see on the survey, for instance, there's a restrictive covenant common to the platted subdivision, I don't get to object to that. Okay. If I see there are that's probably really what it's going to be. Or that are in the commitment other than item 6A1 through 9. So the fact that there is a reservation for tidewaters, like we talked about, not a basis for an objection. Okay. I can't object to those things. Or which prohibit the following use or activity. Now, let's talk about that one for an instance. You've seen this blank filled in 10,000 times, probably 9,995 of those times. It says what?
Single family use.
Yes, residential, single family use. All right. It's a 1 to 4 family contract, y'all. The fact that you're saying single family use, residential use, that's what the contract is for. That is the contemplated use. That means nothing in that blank. What is this blank looking for? And the answer, well, does anybody know? Don't feel bad if you don't. Okay. What we're looking for in this blank is a unique use. Okay. So think about it this way. If you want to be able to have a short-term rental, all right. Now, we're assuming that there's not an issue with short-term rentals because there's a municipal ordinance that might be in place. I'm looking at the city of Dallas, because one of the things that doesn't appear in commitments is all of the laws of the land. Okay. That would be a 10,000 page book. So we're only looking for things in the real property record. So the fact that you're writing in short-term rental use, if there's a municipal ordinance, that's a separate deal. But if there's a restriction in the covenants, conditions, and restrictions, then you get a chance to object. Well, why would I write that there? Because the things I don't get to object to include 6A1. What is 6A1? Restrictive covenants common to the platted subdivision in which the property is located. So that could be all sorts of things. Maybe your client tells you, I've got an RV that I want to be able to park on my property in the driveway. Okay. I've seen CCRs that says you can't have, I've seen them say that you can't have dualies parked out front, big pickup trucks, nonetheless RVs. Maybe you want to have a above ground swimming pool, right? I know you're thinking that's not your market. Maybe you'll run into that person someday, but those are oftentimes prohibited under covenants, conditions, and restrictions. Maybe you've got 5 pit bulls and the CCRs say something about dogs over 50 pounds. Again, maybe there says that you can't have rental property in this neighborhood. Okay. I'm not talking about city ordinances, but something that's in the CCR. If you didn't write in a special use there, you don't get a chance to object to it if it conflicts with the items that are listed in 6A1, which would be title commitment issue B1 and all the hyperlinked documents, right? So think about that. Now, you might be thinking to yourself, I've objected to the fact that I can't do X, Y, and Z, and I've never filled anything in that block. I'm going to say 2 things to that. Number 1, you can get away with anything if nobody knows any better. Okay. That's the God's honest truth. But number 2, if you are buying property that is in a subdivision that has a homeowners association, okay, you are using another addendum. And that addendum says that you get a free look at the covenants, conditions, and restrictions. And I think it's either 3 or 5 days. If you don't like them, you can cancel. Okay. All right. So if you're buying property in a homeowners association, we're less worried about what's filled in this blank. But if you're buying property in an urban area, everything is platted property and everything will have some level of covenant, condition, and restriction. It might just say, you know, the house has to be more than 5,000 square feet, or you can't have a mobile home out here, something like that. It could be really simple, just 1 or 2 things, but you don't know. And if you don't write in your special use, and then you find out that you can't do that thing, and you're not in a property, your property's not in a homeowners association, well, what are you going to do now? You're going to attempt to cancel, and the other party might not know any better, in which case you're safe. But if they do know better, we want to make sure that was filled in. Let's stop there for a second and ask, do y'all have any questions about that?
So I do. So I think I'd never really understood the distinction about like having a municipal law, like the short-term rentals example. So, you know, if you know, Dallas is passing this and you put it in there, but it's not in the CC&Rs, it's really not applicable, right? It would just be your due diligence as a
100%
buyer's
correct.
agent to figure this out.
And so this is a huge issue, right? Because a lot of people have bought houses specifically for short-term rental. Their business model is to buy properties for Airbnb, right? Those people exist. And typically in the past, that's never been a municipal issue. However, Airbnb, VRBO has taken so much revenue from lobbyists who represent the hospitality industry that it's become an issue in Dallas and Santa Fe and all across the country, right? So that is specifically a big issue, but I will just tell you generally, whether it's that or in the past, it was more of an issue sometimes with specific dog breeds. Mm-hmm. There's plenty of CCRs that have restrictions on dog breeds or dog size. Okay. There had also become a point where certain municipalities were coming up with the same restrictions. All right. Again, if it's a municipal ordinance that prohibits you from doing it, that's not an out in the contract. But if it's a CCR, that is an out in the contract. Now, the distinction between those two things goes back to being a competent realtor, by the way. Okay. So this is why you've got to be really familiar with the area in which you're working so that you know a realtor that comes to sell property in Dallas that maybe is working with people in South Padre Island, you know, they're selling their condo, they want to buy something here. They don't necessarily know anything at all about the fact that Dallas has got these coming restrictions. I don't think they're not in effect yet, or did they take effect September 1st? I probably should know that off the top of my head, but I don't.
Should know that too.
So again, yeah, that goes back to competence. Great question. Now, let me back up here real quick. We talked about items 6A1 through 9 above. Now, buyer must object the earlier of the closing date or blank days after the buyer receives the commitment exception documents in the survey. Okay. That blank is oftentimes blank, left blank. I'm talking about little Roman numeral 2. Or maybe sometimes you put 0. Right. Well, what does that mean? All right. So buyer must object the earlier of the closing date or blank. And if the blank is left blank, when do you have to make an objection? Well, if we've got a date that I can't possibly figure out because you've left nothing there or closing, then it's closing. Okay. So as a seller, it would really not be a good idea to leave that blank. Okay. When you get that contract that has a blank there, you fill in some number and send it back and let them initial it or change it. Right. Somebody's going to ask, and they're going to say, what's better, fewer or longer days, fewer or more days? And it really just depends on who you are. Right. Oh, I'm sorry. Here, let me just get this.
So, I mean, guys, just as an example, like we had this happen to us earlier this summer where a transaction coordinator filled out the paperwork for our listing agent and left that blank. And the buyers, they negotiated an amendment like one day before closing, and then still the day of closing, they didn't show up and they objected because this was blank. And Bob, can you tell them a little bit about how the timeline works if someone does object on the closing date? It basically extends the closing.
Yeah, so we're going to get to that in 2 seconds. It's a great question. Okay, so yeah, let's first say, don't leave it blank. And whoever you're working with as a buyer or seller, you guys work with a lot of high-end properties and a lot of high net worth individuals. So they're very possibly represented by attorneys. don't make assumptions, because the attorneys that are making the objections, it might only take them an hour to type up the objection letter, review the documents, but it could be 6 days before they have that hour. So make sure you've touched base with your client's attorneys if they have one to say, how many days do you need to make an objection? Okay. Now, moving on from there. All right. Buyer's failure to object within the time allowed will constitute a waiver of the buyer's right to object. So if you've got 5 days in there and you don't make objections within 5 days, you are not objecting to anything. I don't mean the covenants, conditions, and restrictions above that where you put in single family, where you sometimes fill in single family residential, but maybe you meant to fill in short-term rental. I mean, anything at all we're going to talk about, you waived it. Okay. Buyers failure to constitute a waiver. Buyers are object except the requirements in Schedule C are not waived. Schedule C is what they have to do for us to ensure the transaction, what the seller has to do. And Schedule C, by the way, is going to have all sorts of things, which usually the buyer's not, it's not important to the buyer. However, as an attorney, I would tell you, I would probably still check some of those Schedule C items just for my own benefit, because Schedule C might say everything from, there's a prior unreleased lien. How is that getting cleared? Are you going to get a release for that? Are you going to get an indemnity for that? What is it? I'm probably going to follow up on that. It might say that this person was in bankruptcy. Like, you need court approval. Well, court approval or not, if I'm a high net worth individual or not a high net worth individual, but have legal experience, I'm going to check to make sure that not only it meets the underwriter's requirements, but mine. Not that's going to be a basis for an objection, but I might object anyway. It's going to say things like, well, title came out of a divorce, and in the divorce, there's not a subsequent deed, or there's not a sufficient legal description in the divorce decree. All of those things are things that will have to be fixed prior to closing. So even as a buyer, you might not care that much about Schedule C. As a seller's agent, you're starting there. Like, here are all the issues that we're going to have to deal with to get this thing closed, by the way. Okay. And a great place to start with a lot of those is to start by asking your seller for a copy of their owner's title insurance policy, because we can waive a bunch of those things if we've got a prior policy in place. Okay. There's a thing called a master indemnity agreement that says if this appears on the commitment and you've got a prior owner's policy and it fits within the certain financial criteria, we can start cutting some of these things off. All right. Now, provided that the seller is not obligated to incur any expense, seller shall cure any timely objection of the buyer or any third-party lender within 15 days after the seller receives the objections, and the closing date will be extended as necessary. So back to Zorene's question, if you make the objection on closing because you left that blank, what have we just done? You're going to see that we're going to start pushing the number of days to close out, and it's going to be more than 15 because they have an opportunity to cure, and then you have an opportunity to cancel after that, and it's going to be about 21 days. Okay, man, would that not be good for you to show up to closing with your seller and find out that you're not closing this month, you're closing close to the end of next month? Okay. All right, back to our 15 days. After the seller receives the objections, and the closing date will be extended as necessary. If objections are not cured within the cure period, the buyer may, by delivering notice to the seller within 5 days after the end of the cure period, terminate this contract, and the earnest money will be refunded to the buyer, or waive the objections. If the buyer does not terminate the time within the time required, the buyer shall be deemed to have waived the objections. All right, so we've got several timelines to keep track of. The first one was when we were going to get the commitment by X date. And if we didn't get it by X date, then we have an opportunity to cancel. That's all the way back in our first slide, right? Or not the first, but maybe the first three. Now we got the commitment, and maybe it's not, after 20 days, maybe it's after 4 days. Then the 20 days is irrelevant. We're going to start our calendar on day 4. And now we have a certain number of days that we filled in the blank and little Roman numeral 2 to make objections. They've got 15 days after we make the objections, not after that date that's listed in 2, to then fix the objections. And if the fix is not sufficient, we have 5 days after that to cancel the contract. And if we don't, then we're closing. Okay. So we're going to go through an example here in a couple minutes to help drive this one home. But does that kind of make sense to people? Again, we've got 20 days to get a commitment. Just let's say we get it within that, but we get it on day 4. The 20 days is irrelevant now. We're looking at day 4. That begins our time to make objections. Let's say we filled in 5 days in the blank and little Roman numeral 2. So we got the commitment on day 4. We've got till day 9 to make the objections. We make the objections on day 8. Okay. Then the fact that we had till day 9 is irrelevant. They start counting their 15 days from the day the objections were made. Okay. And then once they make the cure, then we got 5 days to cancel from there. By the way, you're going to get more than one commitment, which means you're going to have to do this more than once. Okay. Now, why are you going to get more than one commitment? Because the commitments are going to be revised. You're probably not going to have a copy of the survey when you turn in the order. And when you turn in the order, that's when we generate the initial commitment, and then we get the survey later, whether that's from a surveyor or it's from the seller with their 247 affidavit. And then we issue a revised commitment that might have new issues that are reflected on the survey. Okay. You're going to get new timelines for those new items, not for the old items, but for the new items. And so you'll have to have 2 different calendars of when the objections for the first one had to come in and the objections for the second one had to come in, et cetera, et cetera. All right. Again, we'll work through an example here in a couple of minutes, but does that making sense to everybody so far? And I'll ask a very precise question. Hopefully it makes sense. I know you don't like it because it's an awful lot, but if it doesn't make sense, please let me know. All right. All right. So buyer may object in writing to defects, exceptions, or encumbrances to the title disclosed on the survey other than item 6A1 through 7 above, or disclose the commitment other than 6A1 through 9 above. What does that mean? What is it, these things that we can't object to? Well, remember, go back to paragraph 6A, which is what we had kind of earlier. These are the things that you don't get to make standard objections to. Now, items 1 through 7 are the only thing that are applicable to the survey. 1 through 9 is what's applicable to the commitment. Okay. But now in here, and I forgot where we have this in the slides. In here, you've already seen that we have a right to make an amendment to what's in the policy in 6A8. Okay. All of you probably understand this, so I won't spend a lot of time talking about surveys, but I will just mention this in case you're newer. Maybe this has never made sense to you at all, whatever the case may be. At item 6A8, it's saying there will be a standard printed exceptions as to discrepancies, conflicts, shortages in area, boundary lines, encroachments, or protrusions, or any overlapping improvements. Earlier, I said we don't by default provide survey coverage. That's what this is talking about. But you might be asking for survey coverage, in which case you check 6A8, little Roman numeral 2. We're going to amend that so that we get rid of all the extra words and say only thing that we're not going to cover is shortages in area, which means at that point we cover protrusions, protrusions and encroachments and overlapping of improvements. Okay. Now for residential policies, that's 5% of the basic rate. It's cheap. I mean, no, you should request it as a buyer, unless there's some reason the market's so hot that the seller has an existing survey. They don't want to get a new one. It's going to be an issue for coverage. I'd rather take a deal that didn't have that if it's really a seller's market. Okay. But under normal circumstances, certainly if it's a buyer's market or if it's kind of a 50-50 deal, you would want that coverage. Okay. Because any title exception that are not objected to or waived, the buyer's attorney is likely to object to anything that might possibly be a problem. Okay. The objection can always be withdrawn later. Has anybody worked in commercial transactions? Okay. We've had a couple. You would know then, and they would tell you then that in the commercial transactions, the minute a title commitment comes out, not the minute, but very soon after the title commitment is issued, the buyer's attorney sends out an objection letter where they object to absolutely everything on the commitment. They don't worry about what they can object to. They don't worry about what's not applicable. They object to everything because it's better to object to something that I can't object to than to waive it. All right. And we'll figure out what's important later. That's what we're talking about is withdrawing it. Most residential transactions, there's no objection ever made. Nonetheless, that doesn't mean there shouldn't be. Attorneys for lenders also submit objections letters. That's not going to be your basis to the fact that you haven't filled in any number of days has nothing to do with the lender. The lender is going to get their opportunity to make objections. And if the lender doesn't get their objections fixed, you're not going to get funding. Okay. We will talk to lenders about what can and cannot be changed. Ultimately, some lenders might be working from out of state. They don't understand Texas policies, and I'll gladly send them the rules like, hey, this cannot be deleted by anyone, not by me, but by anyone in the state of Texas under any circumstances, or it can only be deleted if we get X, Y, and Z. By the way, that rule applies to not me, but everybody who's writing title insurance in Texas. We're happy to explain that. Okay. Technically, the recipient of the objection letter is the seller. So again, whose information is in paragraph 21? If it's yours, remember that timelines are running. If you got the objection letter because your information is in paragraph 21, you better send it to your party right away. However, even though you're the parties for the objection, of course, it needs to be submitted to the title company as well. Okay. and very likely to the surveyor in case we need to have a survey revision. All right. The objections, again, back to this part of the paragraph we're going to talk about here. What can you object to? What might you see in paragraph B10 of your commitment that is typical? I pull this from a commitment. They're all different, right? Because it's specific to your transactions, but there's typically some things that are going to be common to that. So you'll see here, the following matters in terms of the documents creating or offering evidence of the matters, including A, rights of parties in possession. Owner's title policy only. That means it applies to you as the buyer. Okay. What's rights of parties in possession? If you're buying a property that's been foreclosed, if you're buying a property that's a rental property, if you're buying a property where there's a renter, even though it's not a rental property, we've got a tenant. What we're saying is that person might say they've got some right to be there that's completely has precedence over your purchasing of it. Okay. And we're not going to cover that. Can you object to that? Yes, you can. It's in B10. You get to object to almost anything in B10. Almost. Okay, I'll explain the almost in a second. I'll show you on the slides later what we're going to need from a seller to delete that, but that's something you can object to. Any and all restrictions, covenants, conditions, easements, setback lines, and other matters as set forth in the plat recorded in volume 19. Now, this is where we get to the almost anything. Item in this particular commitment, the things that are listed in item B10B really should be included in B1. And that's not typically something you get an objection to. So some title companies will occasionally include covenants, conditions, and restrictions in B10. That doesn't make it objectionable. Okay, but what else do we have in here? Rights or claims, if any of adjoining property owners, looking down at F, of the insured property line between the fence and the property loans is shown on by the survey. There's a survey problem, all right? You've seen that on the survey itself. You've got a right to object there, but you also have a right to object under B10. And it's important to put those two things together because as you're looking at what you requested, you checked, I want the coverage to read shortage in area, right? So you've asked for survey coverage. I'm getting it, right? You're getting it, but we might still be taking an exception to a specific item. Oh, I'll give you survey coverage, but not for that thing because we know for sure it's that problem, it has a problem. What does that mean? Well, that means now you're going to be objecting to that I want the survey coverage without the exception. Okay. And so you'd still have to make an objection to that item. You see, we also have some mineral leases that are listed in there. One of them kind of being a general exception in 10C, an objection to all leases, grants, exceptions, or reservations of coal, lignite, oil, and gas. Generally speaking, we're not providing coverage for mineral ownership. You can get it, but it's generally speaking, it's not being provided. Okay. Can you get it? Well, yes, you can get it if you request it. And it's going to depend, frankly, on where you are, how big of a deal it is, because we're going to require a 100-year search at least because minerals are usually severed ages ago. But we may also require additional things from the seller, which we'll talk about here in a couple slides. Okay. What else might you object to? Items listed in B1. Now, we talked about covenants, conditions, restrictions. If they don't apply, it's not uncommon for examiners to just list all sorts of covenants and conditions and restrictions. I don't want to say it's the usual thing, but it can oftentimes happen, even though the property's been subdivided and broken off, and now that particular CCR that's listed doesn't apply to your particular tract. You will never figure that out from examining it, but the buyer's attorney might figure that out. And that's an objection that would go to the title company, and that is something they could fix. Items listed in B1. Of course, if there's a specific use listed in paragraph 6D of the contract, that's when I was talking about your blank, where you filled in single residential, but now you're going to fill in short-term lease, above ground pool, 90-pound dog, whatever it is, your special use, right? You can object to the general survey exception if you requested survey coverage. Okay, saying that should be amended because we asked for it. And remember that requesting survey coverage, as I just said, is just step one. You might get the survey coverage, but there could still be a specific exception for a survey issue, in which case you're also objecting to that. What else? Any item that's frankly disclosed in the survey other than the standard exceptions called out in the contract. So to give you some examples, you can't object to a platted utility easement because that's one of those standard pre-printed matters. But you could object to the fact that the pool is built into the standard to the platted utility easement because that creates a survey issue, right? You can't object to the fact that there's a 25-foot building setback line, but you can object to the fact that the house encroaches onto the 25-foot building setback line. That's a specific survey issue. Any easement that's not common to the platted subdivision. There might be an easement that your property owner has granted that is unique to that property, okay? Or it's something that's come later and it's not in the plats. That would be all examples of things you're seeing on the survey. Don't assume simply because the underlying thing is something that you can't object to, that the fact that there is an issue with that underlying thing doesn't give you the right to make an objection to it. Does that make sense? Okay, because that was enough attorney speak that you might have just gone, what? All right, still with me. All right, so now let's go through an example of the cure period. So we're going to assume, by the way, and I should have put more on the slide. Let's say you put in 5 days. I'm going to put in my use is, I got this one from COVID. Everybody wanted a chicken during COVID. I didn't understand it, but it was all over the place. Maybe you have chickens. You put in urban chickens in your special use on that blank instead of single family residential, and you give yourself 5 days to make objections. All right, so on day 0, you received a copy of the title commitment, and you object to the deed restrictions prohibiting raising chickens. Again, you might have given yourself 5 days. The fact that you made the objections right away for the seller means we don't care about the 5 days anymore. You made it within that time, but now we're going to start counting our days to fix from the day you actually made it. All right. That starts our 15-day cure period to fix what we'll call is the chicken objection. All right. On day 10, a revised commitment is issued with a fence discrepancy. The fence is on the neighbor's property, or the neighbor's fence is on our property. Okay. Now, as I told you, you're going to get a revised commitment because we didn't have the survey when you turned in the order. So now we've had it, we reviewed it, and we made a revised commitment. And so now we get new timeline to object to the new items. How do you know what's a new item and what's an old item? As standard procedure for title companies, although you might run into one that's not this way, which I have in the past and is really irritating. But the standard procedure is when we issue a first commitment, let's say there's items B1 through 10, and 10 is A through L, okay? Then on the revised commitment, even though we might have taken something out, it'll start with the next letter. So you would be looking at B10M for the new items. We're going to look at the first commitment, where does it end? And then the new item should be listed after that. If we've taken anything off, it's going to just either be crossed out or it will just say intentionally deleted, but they won't renumber them. Okay. They shouldn't renumber them. If you work with a title company that renumbers commitments because they exist, man, does that make it really difficult. Okay. So just check with that. Anyway, back to our example. Day 10, we get a revised commitment with the fence issue that's shown. On day 15, buyer objects to the fence issue. Again, we're assuming we put in 5 days for our time to make objections. So that's timely. That starts the 15-day cure period for the seller to fix the fence issue. Now, on day 20, the fence issue is resolved. Well, let's go back and look. We made the objection on day 15. We know we've got 15 days to cure. They fixed it 5 days later. That's timely, okay? But the chicken objection's never been fixed. So on day 25, we terminate. What's the problem with that? We made the objection on day 0. They had to day 15 to fix it. And then we had till day 20, another 5 days to cancel it. Day 25 is too late. If you're going to both make objections and be competent, you're going to have to calendar when these objections are due, when the responses are due, and when your opportunity to cancel because the cure is not sufficient is due. Okay? And remember, those days aren't hard days. Because you might say, we got 5 days to make an objection. If they make the objection on day 1, then we start the cure period. We're not worried about 20 days, the 5 plus the 15. We're worried about the 15 from when they made it. All right. I'll stop there and ask, does anybody have any questions about how that works? No? All right. You all are still awake. At least it looks like you're awake. If you're not, your background pictures are excellent.
Are you going to talk about the form, like what kind of a form letter we send or email, or is it?
I will mention that. Okay. And I'm going to say I'm going to mention that because let me just give you the spoiler alert. You don't do it. You can't. It would be the unauthorized practice of law. I'm going to show you what one looks like. And remind you of who they go to, but you actually can't do this for your client. You can advise them that they can do it. You can tell them the types of things they might be worried about, but the actual making of the objections is something that has to come either from the client themselves or their attorney.
Okay.
But that's a good question. All right. What about survey objections? Many survey objections can be fixed. Now you got to think about this. Some things can be fixed and some things can't be fixed. If I have put in that I want to have a property that's a short-term rental, and I see that there's a CCR that says that I can't have a rental property here, I can't have short-term rentals, how am I going to fix that in 15 days? That's impossible. I mean, it would require a change of the CCRs, which would mean we'd have to provide notice. We'd have to have a vote of all the property members that are affected, depending on what our documents say, the majority of the property owners in terms of numbers, or the majority of the owners of the acreage, which could be less than a majority of actual owners, or whatever. Maybe it's just one large owner. Probably not going to happen in 15 days. And then I have to be thinking, well, and if I can't fix that in 15 days, if they can't fix it in 15 days, do we want to cancel? We've got a free out, but we have to exercise it within the applicable time. Okay. But the majority of your objections are probably going to revolve around survey issues, and those can be fixed. Okay. So how would you have fixed them? Well, for instance, in the case of the fence, by obtaining something like a boundary line agreement or a consent to encroach. All right. It's typical for driveways that are sometimes built over property lines. It's typical for fences that are sometimes built over property lines, sometimes improvements that are built over property lines, which is kind of a more extreme example, but still happens, where the two owners, and let's use fence as an easier example, or a party wall or whatever. We have a survey, we have an agreement with the neighbor, we attach the survey as an exhibit, and that agreement says, like, we agree that the actual boundary lines of the property are as they're shown in the survey, and we agree that the fence is not on that. Okay. And I'm not going to sue you for moving the fence. You're not going to sue me for moving the fence. Someday when the fence needs to be rebuilt, and it can say anything after that, the party that's making, that is rebuilding the fence will pay to have it surveyed and built on the line, or it'll be done by the one neighbor as opposed to the other, whatever it is. And that agreement's filed of record, and it has to say that it runs with the land. So it's for the benefit of everybody later in the chain of title. What that means is we're not going to have a title claim over this. Okay. And if I get a boundary line agreement to that, everybody's okay with the fact that the fence is where it is. They're not going to claim ownership of the property. They're not going to say it has to stay there forever. I will remove that exception from your title commitment. And now you really have survey coverage for everything. Okay, because I've said I've given you the general survey coverage and I'm not taking exception for a specific item. Now you've actually got it 100%. Before you had it with that one exception. Okay. Maybe we have an issue with access, or again, sometimes with ownership, when I have built my property in a way that I need part of your property and we don't want to get it replatted. So I get a perpetual easement on your property as opposed to you trying to sell it to me, something like that, or an easement, an access for easement. Now, since you work with higher net worth individuals, you might have larger properties. As they get out into more rural areas, you might find that there's an exception on the title policy that says that the driveway isn't located on the easement, something to that effect, right? The easement, in fact, starts where the driveway starts, but then it goes in a straight line and your driveway meanders off. And what we're saying is if the driveway's off and somebody cuts you off, well, they have a right to cut the driveway off, and you're going to have to pave the rest of the easement. Well, you could get a new easement to cover where your driveway actually is, and maybe release the old easement. Okay. You might obtain a waiver from a homeowners association. Let's say, again, your house is built over the building setback line. It's within the last 5 or 6 years. We're worried about there being an issue with that. And so the homeowners association, if they're the ones that are responsible for governing the building setback line, says the architectural committee has approved the fact that the house is over the setback line. Great. We'll take it off. Okay. We might need to obtain a revised survey, because on some surveys, you might see that there is either blanket easements or certain items that are not located. That's not good enough. If I see that there's easements that affect the property, they're going to be exceptions to coverage. If you say, but they're not out there, then I'm going to need the surveyor to tell me they're not out there. And that can be done with a revised survey. Okay. Or a revocation or cancellation of some covenants, restrictions, etc., or maybe even minerals. Some other things, because I know we're running a little short on time. I'm going to pick up here. Again, rights of parties in possession. We talked about possibly tenants. Maybe it's a rental house. Maybe there's a tenant, even though it's not a rental house. Maybe it's that short-term rental. We don't know who's out there doing what and who might have a leasing agreement. Well, you can request that the title company conduct an inspection of the property, and then we get an affidavit from the actual seller talking about the fact that there are no other parties that are in possession or have any rights in the property. And if they're lying, they will indemnify us. Okay, with that inspection and that affidavit, I can take that off. And now you don't have that as an exception. Maybe you're worried about mineral ownership and you want coverage for the minerals. Or maybe you just don't want ownership coverage, but you want to make sure that you get the endorsement that covers damage to the property if there's drilling on your property. Okay. Again, can that be fixed? Yes, that can be fixed. If we're willing to provide coverage for ownership or for the T19 coverages to cover you against drilling for T19.2 or 3, we can get affidavits of non-production from the owners. Now, I'm assuming in this instance that the owners own the property long enough that I will believe them, because those leases will typically say this lease continues in effect basically on into the future unless there hasn't been production for a period of years. All right. And that might be 5 years, could be 10 years. It could be a year or 9 months. Okay. If it says 10 years and you've only owned it for 2, well, then I'm going to need an affidavit from the last owner to say, yes, there hasn't been any production from this date. And then you give me to this date either. That's going to cover at least the 10 years. All right. If you've owned it for 20 years, I just need the affidavit from you. There's been no production out here, my entire period of ownership. Maybe we also need it from surrounding property owners, depending on what we're looking at. But one way or the other, it's addressable. We might also require a waiver of service rights from the actual mineral owners if we're in an area where there's production and we're worried about it. But again, these are all things that the seller could actually obtain and can fix. So what does the letter look like? Well, again, this is something you can't do, but it should come from typically their attorney, but it could also come from them. And it's going to say something like either pursuant to our contractual agreement where we have a right to make objections, we're making all the objections in the attached exhibit A, okay, and then they just list off all the things they're objecting to and why, or it's included in the letter. So you'll see here is an example from a commercial transaction. In order to maintain a consistency, not number 1, but Schedule B2, Item 2, please have the title company acknowledge that the survey will be sufficient to provide the amendment. All right, again, this is for a commercial transaction. Their contracts are a little bit different, but you're getting an idea here, okay? If the survey isn't acceptable, let us know as soon as possible. Schedule B Item 10, the provision should only cover the tax the current year and future years and not the prior years. It might say we're objecting to the fact that there's an exception in B10Q for the fact that the fence is over the property line. Please confirm that will be deleted from the final policy. That's just telling us you're making objections to all these things. It's telling the seller you're making objections to all these things. And now this is triggering the seller's obligation to respond to it. How does the seller respond? Well, pretty simple. You send the documents we talked about how these things are going to be fixed. And if you don't know how they're going to be fixed, you should have a conversation with the title company, because at the end of the day, we're the ones that are taking these items off. So what do we require to get it removed? Okay. You ask us, we tell you. We need a boundary line agreement with the neighbor. We need a surface waiver from these people. We need an inspection and an affidavit, whatever it is, okay? Get those back to us within the time allotted. Now, we're not the ones that typically draft those. We have attorneys that your client might hire to draft them, for instance, the boundary line agreement, but the title agent themselves can't draft the legal documents. An attorney will have to do it. Could be your client's attorney. If it's your client's attorney, make sure they provide drafts to the underwriter so that we can approve them. They're good enough for us to remove them. If your client hires an attorney recommended by the title company, that'll all be handled behind the scenes. It won't be any reason to worry. Okay. Now, that is the thumbnail sketch. And by thumbnail sketch, I mean that's really the view from not even 10,000 square feet. 10,000 square feet, more, not from 10,000 feet. It's more the view from about maybe 30,000 feet. So I expect that there's a lot that you're still not comfortable with. We're up on our time, but I'm going to stay here and answer all the questions you have and say, again, if you think of questions later, I'm going to give you my contact information in the chat. You can just reach out to me and I'll answer that. But let me turn it back over to y'all. Do y'all have any specific questions or general questions? Is he done? Yes, he is. That's one question I know you're thinking. All right, let me do this then.
That was helpful. I think it's a lot. Everyone's probably still consuming, but that was good information for sure.
So let me do this real quick. I'm going to go to the chat. And what I'm going to do is I'm going to do two things. I'm going to type in my email address. Here's my email address. I'm going to give you my cell phone number. Do not hesitate to use either of those. Again, we want your deals to close. Take them to your title company. Hopefully they're underwriting with us. This is the back scratching way, right? So we're here for you because you're going to take it to somebody who's going to bring it to us. So don't hesitate to ask.
Nice to have another expert to know, so thank you.
let me turn this back to you then, and I will hang on just in case anybody changes their mind, but I'll turn this back to you.
Yeah, no, I think we're good. I put the name of the people who have asked for CE credit that are here, and I will send the payment link out to everyone to make sure that you got it. If you haven't paid yet, you need to pay directly to TRG, and I think we'll be good to go.
I will send out again as attachments just the standard T7 title commitment for you guys to just look over, and I'll include a copy of these slides. My contact information will be in the signature block. I'll send it to Zareen. She can forward it to y'all.
Sounds good. Thank you so much.
Have a great afternoon.